That's Rachel Stockman. You don't get a better crew than you do here at the Law and Crime Network. I'm sorry to keep saying it over and over again. I love being on this show because you really have serious talent all over, from the producers and the people in the control room and the guests, and I would hope the hosts as well. And one of those guests is somebody that I've had on before, and I'm really excited to have back again. It's Judge Brandon Birmingham. He's the guy, if you remember, I was always so impressed by the idea that on his bench, facing him, he's got something that says, a plaque that says, "Be humble. This bench does not belong to you. It belongs to the people." And that level of humility, I really greatly respect. I tried to have that myself when I was the county prosecutor. He's the presiding judge in Dallas, Texas. He's a host of A Murderous Design. He was a chief felony prosecutor and cold case unit chief. You didn't think I'd find all this stuff out about you, Judge, but I'm unrelentless in getting my data. And you know what? You started two programs that are dear to my heart because I did this as well in a different form when I was a county prosecutor. The first is the AIM program for nonviolent 18 to 24-year-olds to maybe be diverted out of the criminal justice system so that they're not crushed with felony convictions for the rest of their lives and potentially incarceration. And the high-risk domestic violence court, which I really love because breaking the cycle of violence isn't just about throwing the abuser in jail. You have a holistic approach towards the abuser, but also protecting the abused. How'd I do, Judge? Welcome.
My goodness, you are hired. I want you to do that introduction every time I speak.
Next time you're running for your judgeship, you let me know. I'll come down from Jersey. I'll take a trip to Texas for you. But I'm very impressed, Judge. Listen, this case is really an amazing cold case, the Tara Grinstead case, the 12-year-old cold case homicide that was solved. There is some great lawyering going on. I know we've talked about this before. I love when I see great defense lawyers, great prosecutors, and a really skilled judge who did a really interesting thing on that venue motion. So one of the big motions in this case, Judge, is the statements that the defendant supposedly made. We don't have a lot of data out there right now about how strong the state's case is or isn't. And I've researched in and out with respect to all this, but there's some statements out there that the defense filed a motion to preclude them, which would be the customary thing you would do prior to trial, but pulled back on that. Let's take a look at that, because this is obviously statements of a defendant are huge, usually on behalf of the prosecution, and if the defense wanted them out, I'm assuming that they are not good for the defense. Let's take a look, Judge. We'll be back on the other end. Okay, so Judge, let's just give our audience a little bit of an understanding of what's going on here. In order for Miranda to generally apply, it has to be a custodial interrogation. And what we heard from that factual recitation was that he went, the defendant, to the police station, spoke, if I heard it correctly, it was a little hard in my earpiece, but for 5 minutes and he was not under arrest. The detective then read him his Miranda rights, and that he spoke for an hour and a half. Now, again, these can be tricky issues here, but the state has the burden of proving, typically beyond a reasonable doubt at a motion before somebody like you, that these statements were taken in accordance with Miranda and they were voluntarily given. Can you give our audience a little insight as to you, the judge, how you view those kind of motions?
The first thing I'll look at is I want to identify exactly what the issue is from the lawyers. It sounds to me like the state in this case wants to use everything that Mr. Duke said during his time at the police station, both pre-Miranda and post-Miranda. So what you're looking at in the pre-Miranda is whether or not he was free to leave, if he was in custody or not. Free to leave is the test, because if you're not free to leave, well, then you have to be given your Miranda warnings. Otherwise, you're looking for the statements to be voluntary. It sounds like he went voluntarily down there. It sounds like the detectives had an idea of what they wanted to ask him, so they wanted to interrogate him further. And at the point that he's given those Miranda warnings, he's probably not free to leave. Now you've got, as a judge, to look and make sure the Miranda warnings were given properly, and whether the defendant understood those warnings and whether he properly waived his right to talk with a lawyer, or waived his right to a lawyer, or waived his right of silence, and then he actually did speak with the detective. So those are the things that you're looking at. You're not determining whether the statement is true, whether it's not true, whether it's good for the defense or bad for the state or whatever. You're just determining that those rules were complied with by the police. And if they were, then the statement's going to be admissible. Now, The judge will also be looking for certain other parts in the statement. Let's say the statement as a whole may be admissible, but he says, well, maybe when I got out of jail or when I was in prison before or something like that, well, then you can start taking out certain parts of the statement if you choose to.
Right, the great recitation, Judge, and so our audience knows, because especially people in our chat room, they're real legal scholars loving following this law, that whether you're in custody or not custody could be a very important factual determination. Where was he in the police station? Did he believe he had the ability to leave? Was he in a room that was locked down where there were officers around? Was he provided an opportunity for a restroom, or multiple things? But this was only a 5-minute interview before they read Miranda. But these issues can become factually very tricky, and typically a defense attorney, Judge, we're going to go to a break, but typically a defense attorney does not, at least I would not back off on that motion. I want to get testimony from the cops. I actually had a case about 3 years ago where testimony in a Miranda hearing actually led to a dismissal of the case because the cops contradicted each other and had to take the Fifth Amendment during the course of the hearing. So you never know. Judge, we'll talk about that on the other end of the break. Stay tuned, and we're going to come back more with the judge in a couple of seconds. Okay, you always got to be ready here at the Law and Crime Network, because you never know. And we cut out of that clip a little early, but there's a good positive downside to it. It was my psyche saying, I got to get to Judge Birmingham as quickly as possible, because this Judge Birmingham, my guest, is the real deal. You were a former prosecutor, Judge. I mean, what are you making of this? And as a judge, I've always had the indictment read. Is this something that they do in Texas where you can make a motion to have a judge not read the indictment?
Well, you said, something very interesting to me before we started, and that was that you'd never heard of this. And I got to be honest with you, I've never heard of it either. It strikes me there's some real practical problems with saying that the indictment is not going to be read to the jury. They're going to be told it's a murder case during jury selection. I can't imagine that they wouldn't be. They'd have to be qualified for the range of punishment for a murder conviction. But let's say that the judge says, okay, you're not going to read the indictment. The next step in the trial before the defense has anything to do is for opening statement. And I can promise you that any good prosecutor is going to make an opening statement that doesn't make the defendant look very good at all. So, I'm seeing some real practical concerns with what the defense is asking the judge to do in this case.
Yeah, I agree, and it was interesting to me that the argument was that it was a creative argument that the grand jury does it without the defense. There's no cross-examination, and to let them know that and read the indictment when there haven't been the opportunities that defendants would get at a trial would be inappropriate. So the judge listened to both sides debate about this issue and ruled on or gave indications and rulings on this. Let's take a look. Okay, in the Tara Grinstead case, this is one of a copious amount of motions filed by the defense, and that motion was not to have the indictment read. Judge Birmingham, we were just talking about this on the other end, and it seems like the wisdom of Solomon to me here, where the judge rightly said, I guess based on the judge's opinion of Georgia law, that there's not a real legal basis to compel him to do this, but nevertheless, I really don't read the whole indictment anyway. So he kind of took care of, two birds with one stone. What are your thoughts?
Well, I think that any time that you can find middle ground on a ruling, that's what you're going to try to do. And certainly if it's not supported by the law, then there's no question that you can't do it. But otherwise, you want to try to temper the result of your ruling by trying to give both sides an opportunity to let the evidence and the questions dictate what the jury's verdicts will be. And I think that's a very excellent ruling there by the judge.
Yeah, and just real quick, we have a short period of time. I want to go back to the venue motion just real quick. I thought it was very interesting. Both sides stipulate. I think the prosecutor was kind of blown away when he was trying to say, no, we agree that this should be a change of venue, but the judge also hit the right legal standards there. Well, media is really coming from outside, not from Osceola County, and we can voir dire jurors, but you have given me no data to indicate that you could not get a qualified jury in that county. In 15 seconds or less, Judge, what do you think about that ruling?
That's exactly what we would do here in Texas. The only way to know whether or not there really is any problem with the venue is to start talking to the jurors, and that's the common practice throughout this entire country, and that's what you're going to see there in Georgia. Okay, listen, Judge, thank you so much. We are in the Tara Grinstead case. We got a lot going on here at the Law and Crime Network. If you haven't yet, live stream inside the chat room. Get in there, ask questions. We love to answer them. Judge Birmingham, please stay with us. We're going to be right back. We're going to go to a break. You stay tuned. Thank you.
All right, thank you, Anthony. I just got to make a comment. Only in Jersey could you get a case like that. I'm the only guy that's got immunity and can say that, being a Jersey guy myself, and maybe Linda Kenny Bodden as well, being a Jersey girl. But anyway, listen, we got Ronn Blitzer with us from the Law&Crime Network. He's a senior editor and legal analyst. He also worked as an ADA in Kings County DA office, Cornell Law School, and you know what? Maybe you're allowed to make a comment about Jersey because I know that you went to Rutgers, where you got your media and journalism degree. Welcome, Ron.
Yeah, I'm a Jersey boy too.
That's right.
I lived there for most of my life.
Yeah, we were talking about an area that I actually want to move to, and so me and you both have to be proud of the story that we have there with those individuals trying.
Very much so.
Yes, absolutely. Listen, Ron, Judge, the Jason Van Dyke case, I've done a lot of commentary on this, and actually there's an article on Law&Crime, if you guys ever get a chance to go on there, where we talked about when cops go wrong. It's on the lawandcrime.com website. I just wrote it yesterday. Maybe I'll put a link in there for the chat room people. But the Jason Van Dyke trial is now in part 2. There's a picture of him right now. He is a now defendant, convicted felon. He was convicted of second-degree murder, 16 counts of aggravated assault. He's going to jail for a long time. And Ron and Judge, we actually had a guy who spent 12 years in state prison and is now a prison consultant talk about the difficulty that this cop is going to have in state prison, where he's going to get it both from the law enforcement side and the gang side with respect to this. So he's going to serve some really rough time. But the next case that's coming up is 3 cops who are accused of covering up the shooting case and trying to make it look like Laquan McDonald was actually the aggressor and or more aggressive than he was in order to justify Van Dyke shooting him. But again, we had body camera footage and MVRs that disputed and belied the testimony given by Van Dyke, who took the stand at the trial. So these 3 officers, and that's the part of the article, when cops go wrong, is what happens when you are trying to cover for one of your fellow officers. It was done all the time in the past, but is now being pursued aggressively by prosecutors, and now their lives are looking at being in state prison for attempting to try to help their friend Jason Van Dyke, who is certainly going to be spending a lengthy state prison sentence. Ron, Judge, I want to go to the opening statement of the prosecutor in the Van Dyke case and come back with you and discuss where we think that's going to fit in with these 3 police officers who are being charged with conspiracy, obstruction, and falsification of reports. We'll be back on the other end. All right, that was the prosecutor's opening statement in Van Dyke. The 3 officers are going to go on trial for the cover-up. Ron, you know, as a prosecutor, you know, I've been thinking about this, and in the article I was kind of trying to bring out, arguably, you could say that Van Dyke confronted a violent encounter. It was a split-second decision. It was a bad decision, whether guilty or not guilty, but it was a split-second decision. What bothers me as a prosecutor more so, I don't mean the gravity is different because it's a dead person. Don't get me wrong. I don't mean that. But what I'm trying to say is that these cops, hours later, had an opportunity to deliberate, take their time, and made a very conscious decision. I mean, the evidence is pretty overwhelming, as stated in the arrest affidavits, to falsify their reports in order to cover up this shooting. And I look at that as bad as the shooting itself.
I agree with you 100%. You look at Van Dyke, and he made a decision in the heat of the moment, and you know the jury decided that it was an unreasonable decision, and he's facing the consequences for that. But when you have officers who, after the fact, knowing what happened and having time, as you said, to deliberate, to reflect on this, and then going out of their way to falsify information, that is a whole separate story, because these people are public servants. You know, you look at people in other lines of work who may do something wrong or witness something wrong, and they try to cover things up, and that's always bad. But here you have public servants who are out there to protect all of us, and when they start going into business for themselves and looking out for themselves instead of the people who they're supposed to protect, that crosses a line, and they need to recognize that.
Yeah, I agree, Judge. You know, another thing for me as prosecutor was that, what's good for the goose is good for the gander. I know it's not a sophisticated legal theory, but nevertheless, you as a detective and a law enforcement officer, as a prosecutor, can't be demanding truthfulness and honesty of the people that you interview, except for your people. And I always argued, I actually was on the Attorney General Task Force with regard to incorporating in the guidelines that if you were found to be deceptive or you are found to have been untruthful in your official capacity, that in my mind, that's Brady material that must be turned over to every defense attorney from that point forward so that they can say, the defense lawyers in future cases, well, you lied here and were found deceptive, maybe you lied here, which could basically be a career ender for the cops. Why do they engage in this activity? You were a former DA, you're a current judge. What's happening?
Well, I'll tell you, cases like this they reverberate throughout the entire criminal justice system. When I was a young prosecutor, we had a fake drug scandal here where basically officers were planting pool chalk on folks and saying that it was cocaine, and people were pleading out, and it was a big mess. But it all started with dishonest behavior by those that we hold to a higher standard. And if this case is what the prosecution says that it is, that these 3 police officers, if they can prove beyond a reasonable doubt that they were covering up for a murder, a killing, that's going to reverberate and be an issue in every single future prosecution that Chicago and really that all of the other jury pools are going to have to deal with. Is this idea now that we have a proven case where we have police officers who were covering up in a police shooting.
Yeah, it is. I am a cop supporter. I led 44 police agencies as the prosecutor, but there is this thing where there's this, whitewashing, if you will, or, facts that are getting managed, they would call it, or manipulated. We used to use the term hot washed. In other words, they would be put in the sanitizer. And with me, you did that, you either at a minimum lost your job, but if there were repercussions to another individual, you could be looking at a jail sentence. So we're going to go to a quick break, and we'll be right back. Okay, so, Ron, this case with the 3 police officers who are now alleged to have covered up for Van Dyke, we talked about the fact that this was very deliberate conduct. The statements, and the Law&Crime folks were just great to get us all the information that the government has filed, and here it is, guys. It's a lot of, if it's proven, deceptive conduct. So, as a defense lawyer, do you not want to be working this case out? I mean, there are some who opine that Van Dyke may not have been convicted if he didn't take the stand because his testimony was just horrible and it was just belied by the physical evidence. But these guys, where are they going when they have statements that clearly are contradictory?
Yeah, it's a big problem. As you said, with Van Dyke, he could have gotten away with it depending on how that trial went, if he had said different things or hadn't said anything at all. And that's a case where, as we were talking earlier, he acted in the heat of the moment and made a bad decision. But here, when you have multiple people who are contradicting the facts and in some cases potentially each other, where do you go? As a defense attorney, you don't want to have to go to trial on this sort of thing. So I would think that, if I'm his lawyer, I would want to do whatever I can to try to avoid bringing this before a jury.
Yeah, Judge, this is, from what I understand, going to be a bench trial. So that is a process which the defendants can waive the jury trial. So it would go before somebody just like you. And I want to quote one of our chatters, Tostet, who often chats, and these guys are great. And she indicates, or he, I think it's a she, indicates that taught to have each other's backs from the beginning, and she's not really rabid for them to go to prison. I'm curious, why do you think they went bench trial? And is it maybe the sentimentality that the judge will be a little easier on them and it'll be less of an emotional case? And what would be your thoughts if you pulled this kind of case?
Well, as for the strategy of going to a judge versus a jury, lawyers will oftentimes do that when they want a sterile recitation of the facts as opposed to an emotional one. And certainly jurors can get caught up sometimes in the emotion of a case, and the judge is more calloused, has seen things like this before. And so I think that's probably the thinking on the strategy, why you would choose the judge over the jury.
Yeah, and I'm wondering, you know, I think you're right about that. And if you want an antiseptic, very straight away, not influenced, but then, of course, you have a jury of 1 as opposed to a jury of 12. And I'm curious, just real quick for each one of you, a lot of people feel that the testimony of the defendant of Van Dyke, at least in that case, if you saw it, was the clincher, that he didn't help himself out. And it could have potentially led to a different result, just like the venue change motions that are made, being in one county versus another county, can make a completely different result between guilty and not guilty. What are your thoughts about? Does that bother you a little bit as a lawyer that things could be so disparate and different?
Yes, as an attorney, you're doing your best, and no matter what your tactics are during a trial and what your legal arguments might be, sometimes it's really just out of your hands, because if your client decides to say something a certain way, then that blows everything up. Or if a jury or 1 or 2 jurors just have it out for your client, there's nothing you can do.
Yeah, Judge, I was opining before that even sometimes the judge you have and the county you're in can be the difference between a guilty or a not guilty. I think that's just something that we all know experientially. Do you agree with that?
I do, and it's unfortunate. I wish it wasn't like that. I mean, we'd like to have a system that was equal and treated everybody exactly the same and made decisions based on the law. But I can tell you that the judge, if that judge is convinced beyond a reasonable doubt that those 3 officers did what they're accused of doing, then he will have great and tremendous power to send a message to hopefully, number one, restore some of the integrity of the system that has been surely taken away from. And he will also be speaking on behalf of the entire community that, is affected by the police relationship with those in the community. And it's going to be a very, very lonely day in those chambers, I'm sure, as he's considering what to do in this case. He's also going to have to consider, the fact that, what y'all were talking about before, measuring the deliberateness of this conduct versus this sort of thinking sporadically and this split-second decision that the officer made. Well, that's going to play heavily into his decision as well. The result is the same, too. I mean, you've got a crime and a subsequent action that tried to cover up that crime that shakes this system right down to its core. And that is going to have to be reflected in any sentence that he's going to give.
Yeah, a very interesting point would have been had Jason Van Dyke considered going bench trial only and not taking the stand, whether that would have been a hugely different result because that emotional component would have been removed, from it. On a case like this, Judge, where these are pretty obvious cover-ups to me, at least based on what we see in the record, I'd go jury to hope that you can get at least one really pro cop person, juror that says, I just can't convict, and get to Tostette's point that that she is not rabid for them to go to prison. Just some thoughts bouncing around. That's why I love having guys like you. We got to go to a break. We'll be right back.
Thank you.
Okay, welcome back. So we're breaking down the Van Dyke trial in anticipation for the trial of the 3 officers who are accused of covering up in order to support Van Dyke. As you know, he was convicted of second-degree murder. One of the police officers on the witness stand provided very useful information in Van Dyke and may be called in the next case, where those 3 officers are charged with obstruction, conspiracy, filing false reports, and they are in a whole boatload of trouble. Let's take a look. Okay, let's take a look at Ron, my man. So, Ron, do you think the case is going to play out with the same witnesses in Van Dyke? I anticipate that they're probably going to cut a lot of those witnesses out. I mean, this is really a videotape case, and then they're going to have, I believe, at least 1, potentially 2 officers are going to say that some of these people prevailed upon them to file false reports, but they refused to do it. That's pretty killer.
Yeah, and I agree with you that we're not going to hear a lot of the people who testified during the original Van Dyke case because it's not as relevant. We've already proven legally that that Van Dyke was guilty and that his version of events were not true. So that's going to already help the prosecution in this case. But when you have those that really talked about what happened or what people said happened at that time, less so some of the more behind the scenes kinds of witnesses, that's when that'll come into play in this case, I think.
Okay, so I'm told that clip is ready. Thank you, Ron. And let's take a look at that. We'll be back on the other end. All right, Ron, so we've been talking about what witnesses may or may not also testify in the new trial of the 3 police officers who are accused of covering up in the Van Dyke shooting. That was one of the officers that did testify. I expect that testimony to come out. I think it's going to be compelling to show these are the things that we were doing, this is what McDonald was doing, and that this is how this thing actually unfolded versus what the reports say of the 3 officers that are on trial.
Yes, testimony of a fellow police officer who was there at the time working on this case and knows what other officers were doing, what they weren't doing, what was being said and discussed amongst themselves, and what really happened, I think is going to be crucial in this case.
Yeah, and we were talking a little bit off camera that it is unfortunate, and we spoke to the judge about this too, that the idea of covering up is not a thing that you should be doing, and they're trained and taught. But nevertheless, a small minority of people decide that this is the thing they want to do. Is it cultural, Ron? Is it the way they're raised within the departments? Is it a training issue? Do cases like this help stop that kind of thing? Because if you care about your own career and your own liberty, maybe this is the kind of case that says, don't play around with the facts in your reports and lie.
Yeah, I think that this case could very well be crucial to trying to at least chip away at some of this mentality, whether it's among a small minority of officers or more than that. Personally, having dealt with a lot of police officers, in my past life as a prosecutor, the vast majority of them were, they were solid public servants, always doing their job the right way. But there were certainly, a select few that were known to not always be on the up and up. So I wouldn't necessarily say that this is, a huge corrupt culture that we're dealing with here, but it needs to be drilled into some of those officers who, may not be as honest as the others, that, just because you see something wrong and you want to protect your buddies or yourselves, this is not what you do. You don't cover something up, you don't cover up a crime, because that in itself is a crime itself.
Yeah, and I've represented and handled a lot of police officers in my career as well, both as a prosecutor and defense attorney. But I also know that there's this kind of thing that happens, and I'm not saying it happens everywhere, but we'll give this caveat over and over again. Vast majority of police officers are doing the right thing. But when they get to a point where they're doing the right thing and they're told to do the wrong thing, and they wind up on what we used to call the B team as opposed to the A team, and then their career gets hit with a lot of paper cuts. It is something that definitely goes on there. I think we're doing a better job at addressing it, but we have to give and empower those officers who won't condone that kind of activity, that they're on the A team and not the B team. We're going to go to a break. We'll be right back. All right, we're breaking down the Van Dyke trial in anticipation for the trial of the 3 cops for falsification of their testimony. Now, Ron, that's the centerpiece, obviously. It's a huge piece of demonstrative evidence, but it's what it doesn't show that is going to be most difficult. Van Dyke got up there and tried to explain that he was coming that the victim was coming towards him. He was backing up. At a certain point in time after he says he shot him, he actually was still being an aggressor. And the cops wrote these reports even more that that McDonald was actually an aggressor in this scenario. Why would these cops do this when they know there's body cams and dash cam videos?
It boggles the mind. It really does. You have these officers, they know that there are cameras watching their every move. It's for situations like this, so that this sort of thing can't happen, so that they can realize, oh, we need to be held accountable. We can't just make up certain things because there's documented footage here. And yet they went ahead and allegedly falsified these reports anyway that completely conflict what we just saw.
Yeah, my civil rights experience tells me, having sued police departments in a former life of mine, is that there's a culture, a custom, and a practice in the department where they think they can even get past all of that video and they're going to be supported. I'm just speculating there because a reasonably minded person would not falsify a report when they have all that videotape evidence. Thoughts?
Yeah, I mean, that could very well be the case. If you're in control of the documents that are supposed to tell the story here, and you can change things a certain way, then maybe you can feel like, oh, if there's something else that contradicts it, you can just kind of explain that away because you were the one there.
Right, and I think that comes from the top down. I mean, the tone has to be set. Hey, Ron, listen, it was great having you on. I appreciate it as always when you come on. And guys, listen, we really appreciate your viewership here at the Law&Crime Network. We have been a busy day today. We've handled a couple of cases, a couple of guests. I'm exhausted, but it's always great to be here. I'm going to be back next Wednesday from 12 to 3. I'll be hosting again. I look forward to being with you. And you are going to have the great, the awesome, the spectacular Misty Maris come in and host. You have a great week.